Dear ladies and gentlemen, it is a great pleasure and joy to introduce our dear Professor Kakha Tsikarishvili to you, who graduated in 1999 from the Ivan Yavakishvili Tbilisi State University Faculty of Law. In 2004, he graduated from the American University Washington Law College, where he was awarded a master's degree. He has had a very rich work experience so far. Has worked, for instance, at the Supreme Court of Georgia as a judge's assistant. He also worked as a lawyer for the World Bank's program Court Management Associates. He also worked as a lawyer for the American Lawyers Association. And he has also been able to work in the EU rule of law mission in Georgia, as well as the Norwegian mission of rule of law advisors to Georgia. And of course, he has worked as a deputy chief of the Judicial Administration and Management Reform Project. And most notably, since 2005, he's been working as a lecturer and professor of the Comparative Criminal Course at the Georgian Institute of Public Affairs. He has a very rich palmarès also of publications, but dear ladies and gentlemen, I'd like, with no further ado, to present our dear Professor Tsikarishvili to you, and please enjoy.
Thank you very much, dear Dimitrios, for this presentation, for this introduction. I think we will have, I hope that we will spend a good time during this 45 or 40 minutes, maybe 45 minutes of my presentation. Then you can ask questions about, or you can stop me anytime. If this is urgent, you can stop me anytime and ask the question. I don't have a problem about it. First of all, let me ask you if I can share the screen. As I think I need the permission from the administrator to share the screen, and so that we can have slides. Okay, let's see. Okay, thank you very much. I think that's it. All right. All right. So can you see the slides now? Okay, excellent. So once again, thank you for inviting me to this series of lectures and giving me the possibility to present the topic of today, which is the criminal liability for omissions, a comparative overview. I will be talking about an important subject of a general part of the criminal law, which is liability for omissions. And I will be comparing various legal systems like Georgian, American, and UK, and also French. I would say that there are two different approaches here in this subject, in this area. There is a French system, and there is the Anglo-American and German system. So they are, the Anglo-American and German system, they are quite similar, while the French system is quite different. And we will be talking about those differences and similarities. First, let's ask a question. What is omission and what is an act? Well, probably you would say that, I hope that we have some students with criminal law experience, and they would probably think that this is a very easy question. You know, act is an act, omission is omission. You know, there's no problem in different. It's in many countries, the act is defined as a bodily movement, voluntary bodily movements, which constitutes the actus reus element of the crime. So if you want to do if you want to commit some kind of a criminal offense, you have to do something. You just have to move your finger. and you have to press a button, you have to press a trigger, you have to take a knife, or you have to lit a candle, or you have to do something. I mean, that's the act. But what about the omission? The omission is simple. Omission is failure to act. First of all, the first question would be, why do we criminalize omissions? You know, if you don't do anything, then why are you criminal? That would be the first question. Now, if I don't do anything, why should I be punished, right? That would be the first question. And then we would, then the second question is, what's the difference between the act and the omission, okay? Now, let's talk about the first question. Usually, in the criminal law, the acts are punished, the conduct is committed by action. So the conduct, the crime is usually committed by action. Let's say, you know, the world is perfect, the birds are singing, the people are walking in the streets, you know, they go to the job, they listen to the music, they run in the park. So doing a criminal act means that you are disrupting the universe, that you are disrupting the normal social life, and you are doing something bad. For example, you are killing someone, you are burning a house, or you are committing a theft, you're stealing a property, and so on. This is done by an act. So why omission is punishable? I mean, how can I disrupt a public life by omission? That's the good question, right? In criminal law, however, in some situation, omission is also punishable. For example, in continental Europe, in many countries, it is a crime not to assist a person who is in danger. Let's suppose there is a child who is swimming in the small pool, and the pool is deep. The pool is deep, and the child doesn't know how to swim, so he's gonna die. And I can save the child. I'm a regular, let's say, passerby, and I can save the child. I can just give him my hand, and I can pull the child out of the water, and I don't do anything. That's in many countries of Europe, in France, in Spain, in Italy, in Germany, in Georgia, in Russia. I will be punished for failure to assist the child, and it's a crime. Also, in many countries, it is a crime to not to pay the taxes in a very large amount. For example, in Georgia, if you don't pay the taxes after a certain amount, like 100,000 lari, then you are punishable. You are criminally punishable. If you don't go to the army, and if you are called to the army, and if you don't go to the army, you are also criminally punishable. If you are a witness, you are supposed to give a testimony to the court, and if you don't give the testimony to the court, you will be punished for failure to give a testimony to the court, for refusal to testify to the court. And there are many crimes, but particularly contemporary crimes, which can be committed by omission. Now, so finally, to summarize this part, usually you are committing a crime by action, but in some cases, you can also commit a crime by omission, by not doing anything. Now, about the difference between act and omission. It is, from the very first sight, it's a simple question. It's a simple question, so why should we worry about it? However, in some situations, it's not always easy to differentiate between act and omission. For example, I have, can you see those examples on the screen? D has transmitted, the example number 1, D has transmitted AIDS to his partner through sexual contact without taking necessary precaution. Well, is this an act or is this omission? Well, some people would say this is an act, and some people say, no, 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 this is omission because he did not take necessary precautions. The example number 2, the workers have made a big hole in the road and left it open without any warning sign or fence. A passerby fell in the hole and died. Is this committed by act or by omission? Well, some people would say, oh, wait a minute, this is an action. You know, they made a big hole, and this is why a passenger has died, the passerby has died, because they made a hole. But some people would say, no, 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 this is omission, because they did not do anything to prevent, they did not do anything to guard. Yeah, sorry? Yes, it's a hole. So some people would say, no, 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 they died, the passenger, you know, the citizen has died because of the omission, because they did not make a fence around the hole. Excuse me, do you have a question? Jan, do you have a question? Okay, I will continue, and then you can stop me anytime. Example number 3, mother has put a bottle with a cleaning substance on the floor, and 2-year-old baby came and drank it and got poisoned. Well, is this an act or is this omission? Some people would say the baby died because the mother put the bottle on the floor. But some people would say, no, 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 the baby died because the mother did not take care of the bottle which was on the floor, and it was a poison on the floor. Did not take any precaution. There are several theories, and I'll try to just very simplify. There are 2 basic theories in German criminal law and also in Georgian criminal law. The first one would be about producing energy. If you are producing energy and this is causing the result, then this is an act. And if you're not producing the energy, it's not an act. So in all these examples, this would not be a very good criteria, because all these examples, you are producing some kind of energy, because you are like, you know, the defendant has transmitted AIDS to the partner. In the second example, they were digging a hole. In the third example, the mother put the bottle on the floor. So in all these circumstances, in all these examples, we are talking about some energy. So that's not a very good criteria. The second theory of the differentiating between act and omission would be about reproachable conduct. Which one is the reproachable conduct? Okay, let's take the example number 2. The workers, when they dig a hole, is that a reproachable conduct? No, it's not, because they can dig a hole on the road. Well, what about the example number 3? Is that the reproachable conduct blamable? Is that blamable conduct to put a cleaning substance on the floor? Well, it depends on the location of the child. If the child is near you, then it's reproachable conduct, because the child is in your vicinity. But if the child is not there, then of course you can put the cleaning substance on the floor. It's not a reproachable conduct. So basically, my favorite one is the second theory, which says we should discuss the reproachable conduct if the action is the reproachable conduct, then we are talking about act. But if the action is not reproachable conduct, we're talking about the omission. So in the example number 1, also is not action, because having sex with a partner is not reproachable conduct per se, but not taking precaution is blamable omission. Well, basically, That's quite a theoretical question. It's not a very practical question, but in theory, it's a very interesting question, how to distinguish between acts and omissions in all the situations. Let's go to the next question. There are two types of omissions in the international legal literature, the pure omission and the improper omission. What is the first one? The pure omission is the so-called conduct crime. You don't need any kind of criminal consequences. And in the mixed omission is the result crime. You need consequences in the mixed omission. For example, if you don't pay taxes, this is a pure omission. You don't need any kind of result. But if you are a mother and you don't give food to your child and your child dies, this is a mixed omission, because we are talking about omission and consequences, like death of your child. Let's go to the next person. In Georgian criminal code, we have assistance, what do you call the failure to assist another person. And I think this is in the code of many, many countries in Europe. If you don't assist a child or any, even any other person, like adult or a old or elderly, then you are going to be punishable. Who is in danger? The person who is in life-threatening situation. Then you are going to be punished for failure to assist the person. And this is in French criminal law, they call it non-assistance à la personne en danger. And I think they have a similar norm in countries of Latin America. However, it's not punishable in the UK and in the United States. For example, if in the UK you see a child which is dying in the swimming pool and you don't do anything, you are not going to be punished, and also not in the United States. So these are two different legal systems. If you don't save the child, you're going to be punished in France, in Spain, in Italy, in Georgia, in Germany, in Russia, but you are not going to be punished in America and in United Kingdom. Why? Because there's two legal values: principle of individual autonomy and principle of social solidarity, duty of social solidarity, I would say. In common law countries, it's the principle of individual autonomy which prevails, while in continental Europe, it's the principle of social solidarity. So let's say, Dimitrios, if you are in UK, you can just drop me in the swimming pool, no problem. So you can say, go to hell if you are in the UK. But if you are in France, then you should call the police, or you should give me the rope, or you should jump in the swimming pool to save my life, because you are in continental Europe. Because it's the principle of social solidarity which is prevailing in continental Europe. In Georgia, we would say that everybody should take care of his own aunt. That's the expression in Georgia. And that would be the principle of individual autonomy. Everybody should take care of you should take care of your own business. You should mind your own business. That would be the principle of individual autonomy. But in continental Europe, it's like, you should help me and I should help you. You help me and I will help you. So you have an obligation to help me and I have an obligation to help you. That's the social solidarity. Let's go to the next question. In France, so now we are moving to the next question. Can you actually kill somebody by omission? Can you kill somebody by omission? And there are two legal systems which have different answers. French legal system say French criminal law says no, you cannot kill anybody by failure to act. And continental Europe, Germany, Spain, France, Italy, Latin American countries, Georgia, Russia, most countries of the world, they would say, yes, 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 you can kill a person by not doing anything. You can kill a person. But the French would say, no, 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 you cannot kill him. You cannot commit a murder by omission. That's what the French lawyers, they say. So why is that difference? Why is such a big difference? The French people, the French lawyers, the French criminal law, the legal theory in France is against assimilating omission to commission. They say, first of all, it's against the principle of legality. And secondly, we are talking about hypothetical causation. What about the principle of legality? The French lawyers, they say, our criminal code prohibits murder, but murder means act of murder. It's not omission. It's an act. The murder is an act. So if you are punishing somebody for omission, that's the violation of principle of legality, because it's against our criminal code to punish someone for omission and for murdering someone by omission. And second objection that the French lawyers, they have, is the hypothetical causation. How do you know? How do you know what would happen if the mother gave food to the child? How do you know that the child would not die? If the fireman just poured the water on the fire, how do you know that the fire would be out? If I gave medicine to the patient, how do you know that the patient would have survived? If I jumped in the water to save someone in the swimming pool, how do you know that the person would have survived? How do you know it? Are you sure about it? So that's what the French would say. You are not dealing with a real causation, but you are dealing with a hypothetical causation. It's against the principle of legality again. Now, what about the German and the continental Europe and the rest of the continental Europe? They would say, the Germans, they would say, of course you can kill a person by omission. Of course, you can kill a person by omission. But how is that possible? There were several theories in German literature which try to explain causation by omission. That was a theory of the previous conduct. There was a theory of interference. There was a theory of positive and negative factors, a theory of expectation, and the most common theory, which is both in continental Europe and also in Georgia, and also acceptable in the common law countries, is the theory of expectations. I'm not going to talk about all those theories. I'm just going to talk about theory of expectations, which is adopted here in Georgia and also in many countries. Theory of expectation, that means, let's say, Dimitrios, you are a fireman. So what do we expect from you? We expect you to extinguish the fire. Let's say you are a doctor, Dimitrios. What do we expect from you? We expect from you to save the patient. Let's say you are a father. And what do we expect from you? We expect from you to feed your child. Let's say you are a lifeguard. What do we expect from you? We expect from you to jump in the water and to save the swimmer, to save somebody who is drowning. So this is the theory of expectations, and because Dimitrios is a fireman, we don't do anything to extinguish the fire. Because Dimitrios is a doctor, We don't do anything to save the patient because Dimitrios is in charge of the patient. Because Dimitrios is a lifeguard, we don't jump in the water to save a person in the sea. That's the theory of expectations, which is explaining quite well why omission is causative. Why omission is causative. And there is a status quo theory, but I'm not going to talk about it because it goes too far. If there is a question, then I will go more deeply. Let's say, what is the position of the criminal code of Georgia? The criminal code of Georgia says that in order to kill someone by omission, there must be 3 conditions. What are those conditions? First, there is a special legal obligation to act. Second, you should be able to act. And third, the result would have been avoided by taking mandatory and possible action. These are 3 conditions. Let's take an example. For example, I am a lifeguard, and there is a person who is dying in the sea because of a heart attack. So I did not jump to save that person. All the 3 conditions must be complied. I must have a special obligation. Yes. Do I have a special obligation? Yes. I was able to act. Yes, I was able to act because I have full capacity. I had full capacity. I was trained. I have a special training. I am fully capable to swim. I have a special equipment to save the person, everything. So I'm able to act. What about third? As a result of my conduct, the result would have been avoided. That's the third condition. So if all the 3 conditions are complied, then I will be responsible for murder or for negligent homicide, depending on the guilt, depending on the mens rea. So where does the special obligation come from? The special obligation may come from the law, from the contract, from family relationship, from the profession, from the previous conduct, and from certain social activities. Let's pick up several. Let's pick up some of them. What about family relationship? Family members, they have obligation to care about each other. For example, brothers should care about the sisters. Mother should care about the son. The grandfather should care about the grandson. But now comes the question, what about aunt? What about uncle? Are you supposed to care for your uncle, for your aunt? What about your cousin? Oh, do you care about your cousin? Oh, of course I care about my cousin, but what if you don't care? What if I don't care about my cousin? I'm going to be responsible for murder? So that's a good question. Sometimes, and it's not always clear. For example, in common law countries, you may be responsible for your aunt. In some of the jurisdictions, you may be responsible for your aunt. But in some jurisdictions, no, you're not responsible for your aunt. What about your cousin? No, I don't think that I'm responsible for my cousin. It's because it's too much, it's too remote. But you are definitely responsible for your spouse, for your wife and husband. What about the previous conduct? The previous conduct must be a dangerous conduct. For example, Dimitrios has been driving a car and he had a car accident, and somebody has injured, and there was a passenger there was a guy who was crossing the road, and you hit the guy who was crossing the road. You are responsible for saving that person. You are responsible because your previous conduct was a life-threatening conduct, and you put the person in a dangerous situation, and you are responsible for saving that person. If you don't save that person, you will be responsible for murder. And if you don't save that person intentionally, then you're going to be responsible for murder. And what about the certain social groups? Well, they are talking about, in the literature, they're talking about some activities, for example, mountain climbing. And they say the mountain climbers have an obligation to help each other. And they have special duty to help each other. There are so basically, when we are talking about special obligation, we are talking about the guarantor. We're talking about the guarantors. So once again, let's talk about the guarantors. Who is a guarantor? The guarantor is a doctor, lifeguard, a policeman, a mother, a coast guard, a fireman. Everybody is a guarantor. Those people are the guarantors. So they have special obligation to act. And then there are two types of guarantors, like a caring guarantor and supervising guarantor. The caring guarantor is someone who is responsible for taking care of something or someone. For example, I'm responsible to take care of my child. So I'm a caring guarantor. Who is the supervising guarantor? The supervising guarantor is the person who is responsible to supervise the source of danger. For example, I have a vicious dog, and I'm responsible to supervise my vicious dog. I'm a supervising guarantor in this case. Okay, this is, well, basically, my slides are pretty much coming to the end. And I would say that, of course, there are questions about scope of liability for criminal omissions and for the consequences. Of course, there are questions. For example, a question, I was already asking a question about family relationship. How far does the family relationship go? How far are you responsible? Are you responsible for your former wife? Are you responsible for your wife who is not living with you for many years? For example, I am not living with my wife for about 2 years. I'm responsible. Am I responsible? Am I still responsible to save her life? For example, I'm not living with my child for 20 years. Am I still responsible for his life? Do I have a special duty to rescue my child if he's away from home for 20 years? So these are good questions. There's no clear answer. There's no clear answer in the doctrine. And again, there is one more question about what if you do something, but it's not enough? Let's say, once again, Dimitrios, I'm going to use your name once again. For example, let's say Dimitrios is a lifeguard. He's working at the beach, and he can see that there is a guy who is dying about 200 meters away. The guy who is dying in the sea. And you recognize this is your enemy, and you can recognize this is your enemy. So what you do is that you jump in the sea, but you don't swim fast. You just swim very slowly. You just say, 1, 2, 3, 1, 2, 3, 1, 2, 3, and he died because you were swimming very slowly. So are you responsible for murder? Well, you can say, wait a minute, I have complied with my duty. So I jump in the sea. I'm swimming in the direction of the guy. So what do you want from me to do? Do you want me to break the world record for swimming in the long distance? Do you want me to break the world record? I was swimming in the regular speed. So what do you want me to do? So are you supposed to do your best, or are you supposed to do your normal swimming, or what are you supposed to do? So that's a good question. There's no very clear answer. It's not very clear. Dimitrios can be a world champion, but he can say, wait a minute, I'm a world champion, but this is my enemy. So I'm not going to swim as fast as I can. I'm just going to swim as a regular swimmer. So who is going to blame me? Are you going to blame me because I was swimming as a regular swimmer? Okay, these are good questions. Anyway, I think I came to the end of my presentation. So once again, to summarize, the French people, they are very special. They are very peculiar. And they say you cannot kill by by omission. But the Americans, German, Spain, like Italy, Latin America, everyone is in favor of the causality of the omission. These are the major differences. However, if you go to France, you are still going to be punished. And if you are a lifeguard, if you are a policeman, if you are a mother, you are still going to be punished in France. But you will be punished not as a killer, not as a murderer, but you will be punished for failure to provide assistance. And it's not going to be the same penalty like in Georgia, because in Georgia, you're going to be punished for murder. But in France, you're going to be punished for failing to assist your child. And it's going to be smaller penalty, but still you're going to be punished. Anyway, that's my presentation. Thank you very much. And I am ready to hear any questions that you have.
Well, thank you very much, dear Professor, for this very interesting presentation. And as a matter of fact, I would have a question, but I'd rather be the first one to shoot, since we're talking about murder. Dear ladies and gentlemen, are there any questions from your side to our dear Professor Tsikarishvili?
I think I will just turn off these presentations. Okay.
Well, then I'd rather start, and maybe other people will join then afterwards with their possible questions. So, dear Professor, you've been in touch with many EU missions to Georgia, and you've depicted, of course, the difference actually in the approach to certain criminal legal elements between the continental legal system and the common law system, for instance. So, looking at the development of European Union criminal law, which is developing slowly over the last years, are you optimistic when it comes to a possibility of a future European Union criminal code, which would have matters like omission or acting unified in a sense? What do you think?
That's a very good question. I think that with the globalization and with the unification of the legal systems, with the reapproaching of the rapprochement, I would say, the legal systems, that question will come, will have to be solved, because the French people, the French lawyers, they would say, no, we don't agree with this approach, and the German lawyers, they would say, wait a minute, we have been thinking and talking about it and writing about it for 200 years, and we have such a great legal theory, and so you have to follow us. And maybe, maybe there will be an academic battle between the French and I hope there won't be a physical battle between French lawyers and German lawyers, but just only academic battles. But this is going to be a subject of a debate. I know, as far as I know, it is already a subject of debate, particularly when it comes to international criminal law. And I think I'm not familiar about the subject, but I think in international criminal law, there's no unanimous approach to the causality of omission, because of the French participation and because of the French influence. But this is a good question. I think that there will be a question of how to solve this question on the European level. And I think that's going to be a subject to the future discussion between French model and German and Anglo-American. Yeah, it's a good question. This is an issue which will have to be solved. And also, talking about the national criminal legislations, I think that the national criminal legislations, they will exist for many years and maybe for centuries, because The criminal law has so far. The criminal law has been national by many perspectives. It's a matter of culture. It's not only a matter of legal reasoning and legislative policy, but it's also the matter of culture. Maybe the French, they have a different legal culture, and Georgians, they have a different legal culture. If you stop someone in France, in Paris, like a regular citizen, and you ask a regular, can I kill someone in not doing something? And they will say, probably the regular French citizen, they will say, no, it's not possible. If you don't do anything, you won't be able to kill anyone. And maybe if you stop someone in Georgia and they say, can I kill someone in not doing something? And they say, yes, you can do it. You can do it. If you are a mother and if you don't feed your baby, you will be able to kill your baby by not feeding. Maybe that's a difference. Maybe that's a cultural difference. Yeah, that's my question. That's my answer.
Thank you very much. Further questions, dear ladies and gentlemen? We also have, of course, a couple, for instance, of Portuguese participants here. Do you, dear ladies and gentlemen, see differences or common ground in the Portuguese approach regarding matters of omission, for instance?
So let's say if, for example, if mother does not feed child in Portugal and child dies, is this going to be a murder or is this going to be a failure to assist the child? Because that's a big difference. It's a very big difference. If it's a murder, then you can go to jail for 30 years or for lifetime. So it's a very big difference between these two crimes. But I think in Portugal is the same like in Spain. I think that they have the same approach like in Spain and like in Italy.
Any further questions, dear ladies and gentlemen? Any comments or remarks, maybe?
So I would like to say something. First of all, I would like to say thanks for such an interesting lecture. Originally, I'm from Russia, and I noticed, by the way, a lot of similarities when you talked about similarities and some other things between Russian legal system and, for example, Georgian, Spanish, or something like this. But for me, it was a little bit weird, strange that France, for example, has some other way to solve this kind of crimes. And why it's so strange for me, because I know that France, for example, belongs also a Romano-Germanic legal system. And that's why I ask myself, so why it's so big difference between between such countries? So in general, I notice a lot of similarities. Thank you so much again. Actually, I graduated from my Russian university for 10 years ago, so it was a long time ago. But anyway, I remember a lot. And it was really interesting to hear and to remind myself how it works. Thank you.
Okay. Thank you very much, Olga. That was a good question. Why French have such a peculiar approach? I think because the French criminal law was developing quite in isolation from the German. Despite the fact that they are neighbors, they don't read very much each other's legal literature. So the French lawyers of the 20th century and of the 19th century, they were not too much familiar with the German legal writings, and the French criminal law was developing quite in isolation from the German criminal law. I think that the German criminal law is one of the most profoundly elaborated from theoretical point of view, because in Germany you can see hundreds of dissertations, hundreds of manuals on every small topic, hundreds of different manuals on every small topic. And in France, you don't see many writings about causation and omission. You don't see many of them. I know some of them, but when you read when you read a criminal law manual in France, just a regular criminal law manual, you don't see too much debate on this subject. They are discussing on 2-page or 3-page the question of omission and causation, but not too much. But in German criminal manuals, you see hundreds of pages. You see, I don't know, 20-page or 25-page of discussion of omission and causation. They are focused too much on the subject. But however, I think, first of all, this was a culture, as I said, this was a cultural difference. I think it's also a cultural difference. The French, they think that you don't kill anyone by omission. That's probably a cultural phenomenon. And the German and the Americans and Spain and Italy and Georgia and Russia, and we think that you can kill a person by not doing anything. I think it's also cultural. It's also a cultural phenomenon.
Thank you for the answer.
Thank you. Thank you.
Well, dear ladies and gentlemen, are there any further questions? If that is not the case, I'd like to thank you, dear Professor, once more for this very interesting presentation and also for the question and answer session, and to also thank you guys, dear ladies and gentlemen, for being here with us once more. Thank you, dear Andrea, for providing as always, the online room for us to meet each other. So have a nice day. Thank you very much.
Thank you.
See you soon.
Have a nice
again.
day. Bye-bye.
Bye-bye.
Bye-bye.